Okay, let's unpack this. Imagine the weight of being a barrister. You're seen as this, guardian of justice. People put immense trust in you, clients, the
Yeah.
courts.
Absolutely. It's a role built really almost entirely on that foundation of trust.
But what happens when that trust is, well, shattered? Not because you lost a case, but because of choices made, behind the scenes. Choices that seem to spiral into desperation,
Yes.
deception.
And that trust, it's fundamentally linked to the absolute bedrock requirement for anyone practicing law, especially as a barrister. You must hold a valid practicing certificate.
Right. It's not just admin, is it?
Not at all. It's more than just like a piece of paper. It's the formal stamp from the profession, from the regulator saying, yes, this person is fit and proper to hold this unique position to serve the public.
Exactly. And here in New South Wales, that regulator is the Bar Council. They're the gatekeepers, basically, making sure professional integrity holds up, ensuring public confidence stays strong.
So when that foundation, that certificate gets compromised, well, the whole structure starts to look shaky.
And what we have for this deep dive, based on material you, our listener, actually sent in, is the story of one barrister's fall. A really specific case involving a guy named Patrick Mack.
And it's a case that goes way beyond just a simple regulatory slip-up. It's got these elements that honestly turn it into a compelling, almost dramatic narrative.
Like what?
Well, there are allegations of an attempted cover-up, talk of secret deals, and get this, even a private investigator showing up on someone's doorstep on Christmas Eve.
A private investigator.
Yeah.
On Christmas Eve. Okay, seriously, now I'm hooked. Wow, this isn't just a dry legal analysis.
No, definitely not. It's a cautionary tale, but one with, some real dramatic flair.
So our mission here is to cut through all the procedures, the legal findings, to really understand what happened, who was involved, and crucially, what are the vital lessons here, especially for anyone thinking about or starting a career in law.
Yeah, think of it like a procedural true crime story, almost. One that takes us from someone's personal troubles right through to potential professional ruin. And it really highlights the ethical lines that, well, you just can't cross.
So we'll follow the journey
Hmm.
through the disciplinary process, the courts.
Exactly. We'll look at the key players, the legal teams involved, and how they changed, and really dig into the heavy implications of the final findings.
All right, get ready, because we're about to dive deep into what sounds like the double life of a barrister. And this elaborate scheme, the sources say, brought it all crashing down. First up, let's meet the cast, the dramatis personae in this cautionary tale.
Okay, so the central figure, obviously, is Patrick Mack. The sources tell us he was admitted as a lawyer back in NSW, December 2009, and he held a practicing certificate, a PC, as a barrister without any restrictions from October 2011 right up until June 30, 2020.
So quite experienced then, not a newcomer?
No, definitely not. Several years of experience. Interestingly, there's a note he changed his name in August 2019. He was Patrick Bernard Lott, became Patrick Fordham Mack.
Okay, so an established practitioner. But the sources suggest that despite that experience, he was facing some pretty big challenges leading up to all this.
Yeah, that seems to be crucial context. Significant challenges, both personal, including some serious criminal charges we'll get into, and also financial stress. Apparently, this was made worse by the whole COVID-19 situation impacting court work.
Right. Court closures and delays hit everyone hard, especially barristers relying on appearance work.
Exactly. These pressures, personal and financial, they seem important for understanding the path he ultimately took.
Okay, who else is involved?
Then there's Mrs. Sina and her son, Mr. Osipov. Mr. Osipov was facing criminal charges, and Mrs. Sina, his mother, was the one trying desperately to find legal help for him.
And she's described as a layperson.
Yes, the sources portray her as someone less familiar with the legal system, maybe a bit vulnerable in that situation, and her interactions with Mack become, well, a real focal point later on.
How did she even connect with Mack?
Through someone named Casey Roberts. She's described as a mutual acquaintance, a friend of Mrs. Sina's. She referred the case to Mack.
Just trying to help, presumably.
Seems that way. Well-meaning, probably, but ultimately quite consequential because she linked Mack to this potential client at a really critical time right when his own regulatory issues were bubbling up.
And then there's the PI, John Stewart.
Right, John Stewart. The sources identify him as a licensed private investigator hired by Mack, and his specific actions visiting Mrs. Sina on Christmas Eve 2020 with cash and a pre-drafted document.
Accompanied by a JP, a Justice of the Peace.
Yes, that too. This whole visit became a key piece of evidence in what the Bar Council later called Mack's elaborate scheme to try and cover things up.
Wow, it really does sound like something out of a movie. A PI, Christmas Eve, cash, a statutory declaration. Just incredible. And through all this, various legal teams are popping up.
They are. The Bar Council, acting as the regulator, they had consistent senior representation throughout Mack's proceedings. Peter Griffin, SC, that's senior counsel, a top barrister leading the team, working with Hickson's lawyers.
That consistency from the regulator is important, isn't it? It shows they're taking it seriously.
Very seriously. It underscores their commitment to pursuing these matters thoroughly.
But on Mack's side, the picture was different.
Quite different, yeah. For his first big hearing at NCAT, that's the NSW Civil and Administrative Tribunal back in 2020, when he was fighting to get his PC back temporarily, he had senior counsel, Saul Holt, SC, along with Murray and Agnew solicitors.
So a proper high-level defense effort initially.
It looks that way. But significantly, by the time we get to the main misconduct hearing before NCAT much later, the sources say Mack was largely self-represented. No counsel of record listed. Just him facing the Bar Council's experienced team.
That shift from having senior counsel to being on his own, that feels significant.
It really does. It sort of paints a picture of perhaps increasing isolation, maybe dwindling options as the regulatory process tightened around him.
Does this happen often?
Well, the sources also mention the legal teams in that earlier Dwyer case counsel of NSW Bar Sucker v. Dwyer, which is sort of a precedent here. In that case, the Bar Council also had senior counsel, Kate Williams, SC, with Hickson's. Dwyer himself had a solicitor involved, but was self-represented in court. So this pattern of facing serious regulatory action essentially on your own, it's notable and probably quite daunting.
Okay, we've got our players. Now let's trace how this spiral really began for Patrick Mack. The sources are pretty clear. His troubles didn't start with, say, messing up in court, did they? They started with personal stuff.
That's a really key point. The sources detail criminal charges laid against him before any of this professional misconduct stuff surfaced publicly. He was charged with 2 counts of stalk or intimidate domestic violence related, and 1 count of using a carriage service to menace or harass.
Serious charges.
Very serious. Indictable offenses involving his former wife.
And just being charged with those triggered an immediate professional obligation for him, right?
Immediately, yes. Under the Legal Profession Uniform Law, the LPUL, being charged with offenses like these is what's called a show cause event. Section 51 of the LPUL is crystal clear. A lawyer must notify the Bar Council within 7 days. And not just notify, but explain why. Despite these serious charges, they should still be considered a fit and proper person to hold that practicing certificate.
And right here, at the very first hurdle where his personal life impacted his professional one, we see a failure.
The first major one, yes. The sources emphasize Mack failed to notify the Bar Council within that mandatory 7-day window after being charged.
Did he offer any reason later?
Later on, yeah, explanations mentioned in the sources included things like being unaware of the specific rule or being under immense stress. But look, the bottom line is it was a clear statutory breach right from the outset. Not a good start when dealing with your regulator.
Not at all. So the criminal case proceeds. What happened with those charges?
Okay, fast forward to July 8, 2019. The matters are finalized in Manly local court. Mack ended up being convicted on 2 counts. One of stalk intimidate, domestic, and that carriage service charge. He pleaded guilty to those.
But hang on, the sources mentioned he tried something before pleading guilty. A dramatic legal maneuver.
Ah, yes, that's right. Before entering the guilty pleas, he tried to get the charges dealt with under mental health legislation. He made applications under Section 32 of the relevant NSW Act for the state charge and Section 20BQ of the Federal Crimes Act for the Commonwealth one.
What was the goal there?
The aim, essentially, was to convince the magistrate to dismiss the charges on mental health grounds. If successful, it would mean avoiding a formal conviction and avoiding the professional fallout that inevitably comes with convictions for serious offenses.
Trying to sidestep the consequences, basically.
That certainly seems to be the implication. But it didn't work. The magistrate refused both applications. It was only after those attempts failed that he pleaded guilty and the convictions were recorded.
Right. And this is where we hit another critical failure, a really astounding one, actually, regarding his professional duties.
Yeah.
What did he do immediately after being convicted on July 8, 2019?
This timing, it's honestly incredible. The sources state that immediately after being convicted on that very day, July 8, Mack again failed to notify Bar Council within the required 7 days.
Again.
And instead of dealing with this mandatory notification triggered by the actual convictions this time, what did he do? He went on a 2-week overseas holiday with his children.
You're kidding. A 2-week holiday. right after being convicted of serious domestic violence and harassment charges that demand immediate notification to the bar. That beggars belief, especially for an experienced barrister.
It shows, frankly, a staggering lack of judgment regarding his professional responsibilities. The sources frame it exactly that way, highlighting the timing, the misplaced priorities.
So when did the Bar Counsel find out?
His solicitors eventually notified them on July 26, 2019. The explanation given was the delay was due to the trip in needing to get the conviction documents. But the damage was done. This was the second time he'd breached the 7-day rule. It created a pattern, and it severely eroded any trust the counsel might have had in his fitness and honesty.
And his practicing certificate was sort of up in the air at this point anyway.
Yeah, his annual PC for the 2018-2019 year had technically expired on June 30, 2019. But there's a rule under the uniform law that lets a PC continue temporarily while a renewal application is pending.
But
now, with these convictions officially on his record, plus the 2 failures to notify about them promptly, the Bar Counsel had very strong grounds to refuse that pending renewal application altogether.
So the personal legal issues directly led to regulatory breaches he ignored, and the convictions then gave the counsel the power to deny his license renewal. Okay, so this brings us to the next stage. The counsel actually refusing the PC and Mack fighting back.
That's exactly right. The Bar Counsel reviewed everything, the criminal outcomes, the notification failures, and apparently other complaints about his conduct too, the several cases mentioned in the sources.
So it wasn't just the convictions.
Potentially not just the convictions alone, though they were likely the main driver. After considering all that, the counsel took decisive action. On June 30, 2020, they formally refused to grant Patrick Mack a practicing certificate for the 2019-2020 year.
June 30, 2020, that's the date. The day his official permission to practice as a barrister ended. That's huge.
Monumental for his career. It was a formal decision by the regulator saying, based on the evidence, we do not consider you fit and proper to hold a PC right now. The refusal letter likely cited the convictions, the failure to show cause adequately, and maybe reference those other ongoing issues.
And Mack didn't just accept this.
No, he fought it. He had the right to appeal the Bar Counsel's refusal to NCT, the tribunal. The sources describe this as him fighting for his professional life, his livelihood, his reputation, his whole future as a barrister was on the line.
And as part of that appeal, he tried to get a temporary PC, like a lifeline, while the main appeal was heard.
Exactly. He made a specific application asking NCAT to grant him an interim practicing certificate, basically saying, let me practice while the full appeal against the refusal is sorted out.
What was his argument for that?
Likely focused on needing to work, the financial hardship argument, especially with COVID impacting courts, as he mentioned in evidence. He might also have argued things about rehabilitation or perhaps disputed the basis of some of the complaints against him.
So there's a specific hearing just for this interim request.
Yes. That hearing happened on August 14th, 2020 in the NCAT Occupational Division. And at this point, remember, Mack had senior counsel Saul Holt SC with Moray and Agnew solicitors. They were arguing his case against the Bar Counsel's team, led by Peter Griffin SC for Hickson's lawyers.
What's the core issue in a hearing like that?
Yeah. The tribunal has to weigh things out. It's the potential irreparable harm or hardship to Mack if he can't work versus the potential risk to the public, to clients, if he is allowed to practice, given the convictions and unresolved issues.
And it was during this hearing, while he's arguing he is fit to practice, that something else came out, something really damaging.
This is where it gets even heavier, yeah. The sources highlight a pretty shocking disclosure made during that August 14 hearing. It emerged that just days before, literally between August 5 and 12, 2020, Mack had been charged with a new, very serious offense.
Another one.
Yes. Contravening an AVO, an apprehended violence order, another domestic violence-related charge involving his former wife.
Oh my goodness. A fresh domestic violence charge coming to light while you're literally in a hearing trying to convince a tribunal you should be allowed to practice law. That's devastating for his case.
Devastating. It would have completely undermined any argument about fitness, low public risk, or rehabilitation. How could his lawyers argue he wasn't a risk when these new, serious allegations had just surfaced?
So what did the tribunal decide about the interim PC?
The decision came down on August 25, 2020. Deputy President Judge D.C. Cole presided. The application was refused, flat out.
What was the reasoning?
The tribunal just wasn't persuaded. They were not convinced that Mack's need to work or any other argument he put forward outweighed the clear risk to the public and to the administration of justice. Allowing a barrister with recent serious convictions, plus brand new charges disclosed mid-hearing, to practice, even temporarily, the risk was deemed too high. The bar counsel's refusal stood. He remained formally, definitively, without a license.
So at every single stage, the charges, ignoring notification, the counsel's refusal, the NCRM hearing, the system was saying, no, you are not currently fit to practice. It's quite something.
It is, and yet, the sources reveal this incredible, dramatic irony. During this exact period, while he was fighting and losing that battle for the interim PC, Mack was already doing things that would form the basis of a whole separate major professional misconduct case against him.
You mean the stuff with Mrs. Sina?
Precisely. As the tribunal pointed out later, completely unknown to them when they refused his interim PC on August 25th, Mack was already involved in the sequence of events leading to the allegations about the consultancy with Mrs. Sina and the subsequent elaborate scheme.
Which brings us to the massive gamble he took, engaging in what the tribunal later found was unlicensed practice, dealing with Mrs. Sina and her son.
Yeah, this is where it all started falling apart in a new way. It began when Casey Roberts contacted him. Remember, the mutual friend.
Right. She contacted him about Mrs. Sina needing help for her son, Vlad Osipov, criminal charges. She asked if Matt could personally handle it.
In this moment, right here, is a critical turning point. It shows a fundamental ethical lapse, because the sources have text messages showing Mack's replies. These are replies he sent after his PC had been formally refused by the Bar Council on June 30th, and while he was waiting for that NCT decision on the interim PC, which came down August 25th, he knew he was barred.
So what did he say in the texts?
He was confident, maybe overly confident, and certainly misleading. He sent texts reassuring Mrs. Roberts and Mrs. Sina he could definitely take the case. The sources quote him saying things like, "No, I can do it. I have my new firm starting next week."
A new firm?
Yeah, maybe an attempt to imply he had some other way to practice. And another text, "I will be taking his case, Irina." It wasn't like, oh, maybe if I get my license back. It was a direct assurance he would handle it, knowing full well he couldn't legally do so at that time. It was a deliberate misrepresentation to get the client, basically.
Wow. Okay, so he misled them to get the case. What happened next?
They set up a meeting. The sources describe it happening on August 9th, 2020. Mack met Mrs. Sina. He took down Mr. Osipov's history, spent about 30 minutes, apparently, discussing the case details. And crucially, at this meeting, he took $3,000 in cash from her.
$3,000 cash?
$3,000 cash. Mrs. Sina later gave evidence that he discussed her son's case, explained aspects of it to her.
And he didn't just take the money and stop there, did he? He started acting like the barrister on the case.
He did. He began engaging with the instructing solicitors who came on board, Andrew Pasternacki and David O. from Strathfield Legal. The sources detail emails where Mack is basically instructing Mr. Pasternacki, suggesting how to draft advice on the charges, talking about case strategy, even mentioning appearing in court with him.
And how did he sign off these emails?
As barrister.
Yeah.
And used his old chamber's address, actively reinforcing the impression he was properly engaged as counsel. There's even a text message quoted where he's asking for the charge sheets and says, "Once I get through this NCAT hearing, I will be returned to practice and I will see Vlad Monday."
So he's completely acting the part, giving instructions, planning appearances, taking money, all without a license. What did the instructing solicitors think was going on? Did they know?
That's a really key point for the tribunal's findings later. The sources include pretty compelling evidence from Mr. Pasternacki and Mr. Oak. They testified they genuinely believed Mack was able to act as the barrister. They said they weren't aware of his regulatory problems or his lack of a PC until later.
They believed him.
Yes. Mr. Pasternacki specifically said if he'd known earlier, he definitely would have asked about Mack's situation. And he said Mack's emails and texts all supported his belief that Mack was properly involved as the barrister. Even Mrs. Sina had saved his contact in her phone as Patrick Lawyer. All the objective evidence pointed to him presenting himself and acting as a barrister.
But Mack himself, when challenged later, tried to argue this wasn't actually legal practice at all.
He did. That was his main defense to the tribunal. He claimed it was never meant to be legal work. It was just a consultancy agreement.
A consultancy?
Based on what? He claimed he was only hired to advise Mrs. Sina on police procedure, drawing on his past experience as a police officer. He argued he wasn't giving legal advice as a barrister, and the $3,000 cash was purely for this non-legal consultancy.
How did the tribunal react to that explanation?
They didn't buy it at all. They found it deeply unconvincing. The sources highlight Mack's own cross-examination, where he actually admitted his so-called consultancy involved things like building an evidence matrix, assessing the legality of search warrants, and evaluating whether the police acted lawfully.
That sounds an awful lot like legal work.
Exactly what the tribunal thought. They pointed out quite rightly that this work inherently involves applying legal knowledge and analysis to a specific criminal case strategy. It's work typically done by a lawyer. His claim about special knowledge from policing. The tribunal countered that assessing warrant legality is a standard legal task any competent lawyer does. It wasn't some unique police insight.
So they saw right through the attempt to just stick a different label on it.
Absolutely. The tribunal's conclusion was stark, unambiguous. Mack agreed to provide services that were plainly legal in nature, taking the fee, meeting the client, developing strategy, liaising with solicitors at a time when he was legally prohibited from doing so. They found this was the very definition of engaging in legal practice while unlicensed.
Okay, so the unlicensed practice, accepting the money. This eventually led to Ms. Acina complaining to the bar counsel. Presumably when she realized he couldn't actually act for her son and wanted her money back.
That seems to be the sequence, yes. The sources indicate she lodged a complaint after it became clear Mack wasn't getting his PC back, and the issue of the $3,000 refund arose. And Mack knew she wanted the money back pretty early on. There's mention of a text message around mid-August 2020, so he must have known a formal complaint was likely brewing.
And this awareness seems to be the trigger for what the tribunal called the elaborate scheme.
It really looks like it. Instead of just refunding the $3,000 cash in a normal, transparent way, bank transfer, maybe through a solicitor's trust account.
Which would be the proper way.
The absolutely proper way. He devised this different, highly irregular plan. He hired the PI, John Stewart. He arranged for a justice of the peace to go along with Stewart. And their destination, Mrs. Cease's home. The timing, Christmas Eve 2020.
Christmas Eve. It just keeps sounding more bizarre and desperate. And they didn't just turn up with the cash, did they?
No. Mack himself drafted a statutory declaration, and he wanted Mrs. Acina to sign it.
What did this document say?
Its purpose, according to the sources and the tribunal's findings, was transparently self-serving. It was designed to make Mrs. Acina effectively retract her complaint to the bar counsel. It aimed to get her to state, formally, that she had only engaged him as a consultant, not as a barrister. Basically, a document designed to exonerate him from the professional misconduct allegations.
So let me get this straight. A private investigator and a JP turn up, pretty much unannounced, at the home of a vulnerable client's mother on Christmas Eve, holding $3,000 cash, and pressure her to sign a legal document pre-written by the very person she's complained about, a document designed to protect him.
That is precisely what the sources describe happened. John Stewart's visit. Apparently, only about an hour's notice was given by phone. Ms. Acina's evidence, which the tribunal accepted as credible, was that Stewart didn't explain she didn't have to sign it, or that she could, get independent legal advice first.
Of course she should have been told that.
Absolutely. The visit itself was very brief, maybe 10, 15 minutes. And critically, the sources quote Stewart admitting under cross-examination that yes, the return of the cash was linked to the signing of the statutory declaration.
So it was conditional, sign this, get your money back.
That was the clear implication. Miss Acina signed the document. She got her $3,000 cash back. And Mack. According to the sources, he was waiting just down the street.
Waiting down the street, orchestrating it but keeping his distance. The tribunal must have come down incredibly hard on this.
Utterly scathing is the word used in the sources. The tribunal found Mack orchestrated this elaborate scheme, knowing full well he had no lawful basis to keep Miss Acina's money once she'd complained, and the retainer, such as it was, ended. They found his attempt to make the refund conditional on her signing a declaration favorable to him was completely improper.
What specific issues did they identify?
They highlighted the severe conflict of interest, a real and substantial conflict. Here he was, dealing directly with a complaint against himself, using a PI and a drafted document, targeting a layperson, exploiting her lack of legal knowledge, purely for his own benefit.
That conduct just feels so fundamentally unethical, damaging to public trust.
Exactly. The tribunal described it as conduct utterly unbecoming of a barrister. They saw it not just as a conflict, but effectively as an attempt to interfere with a potential witness, Mrs. Acina, in the disciplinary proceedings he knew were likely coming.
Did they find this scheme breach specific conduct rules?
Yes. Interestingly, while the tribunal ultimately wasn't comfortably satisfied that the unlicensed practice itself met the specific definition in Barrister's Rules, Rule 8C, which talks about conduct likely to diminish public confidence or bring the profession into disrepute, in addition to being professional misconduct under other definitions. They explicitly found that this Christmas Eve scheme involving Mrs. Acina did violate Rule 8C.
Ah, so the attempted cover-up was found to directly harm the profession's reputation in the public eye. That makes sense. Okay, so from unlicensed practice to this elaborate scheme, this all culminates in the final showdown, the reckoning before the NCAT Occupational Division.
Yes. The formal application seeking disciplinary orders against Mack was lodged by the Bar Council in January 2022. The actual hearings at NCAT took quite some time, spread over several days across June and November 2023, and then again in April 2024. These things aren't quick.
Who heard the case at NCAT?
It was a 3-member panel in the Occupational Division, including senior judicial and legal members. And representing the Bar Council, again, consistent presence, Peter Griffin, SC leading, with Hickson's lawyers instructing.
And Mack's position during this crucial hearing, we mentioned he was self-represented.
Largely, yes. His earlier legal team was gone. No counsel of record. So it was him, essentially on his own, facing the Bar Council's experienced senior counsel. The sources note he actually cross-examined Ms. Acina and the other witnesses himself.
Wow. Cross-examining the people providing evidence against you. That must have been incredibly difficult and potentially very uncomfortable for everyone in the room.
You'd have to imagine so. A very challenging situation.
So what was the core of the Bar Council's case at this stage?
They focused squarely on the allegations arising from the Acina matter, primarily. 1, that he engaged in legal practice or held himself out as entitled to practice while he was unlicensed, and 2, that he accepted that $3,000 fee for providing legal services while unlicensed.
And the evidence?
They presented all the evidence we've discussed, the text messages, I will take his case, the email signed Barrister, Miss Acina's phone contact, Patrick lawyer, the details of the $3,000 cash payment and its eventual return via the PI, and crucially, the live testimony from Miss Acina and the 2 instructing solicitors, Mr. Pasternacki and Mr. O.
And how did Mack's defense, the whole "it was just consultancy" line, hold up under scrutiny during the hearing?
Not well at all, according to the sources. His defense was significantly undermined, both by the weight of the Bar Council's evidence and by his own testimony under cross-examination.
In what way?
Well, his claim of a simple consultancy on police procedure just didn't stack up against the nature of the work he admitted, doing the evidence matrix, assessing warrants, strategy, which was clearly legal analysis. His cross-examination also revealed inconsistencies, things like being unable to produce any notes from his meeting with Mrs. Acina. And the tribunal found his explanations implausible, especially his claims about what he told the instructing solicitors, or his shifting story about Casey Roberts being party to this supposed consultancy agreement.
So his version of events just wasn't believable to the tribunal.
That's the crux of it. A critical part of the tribunal's final judgment involved findings on credibility. They explicitly stated they preferred the evidence given by Miss Acina, Mr. Pasternacki, and Mr. O over Mack's account.
How did they describe his defense?
They called it an unconvincing attempt and a reconstruction. Essentially, they felt his story was something crafted after the fact to try and fit the allegations rather than reflecting what actually happened at the time. The sources also mentioned the tribunal specifically drawing parallels to the earlier Dwyer case again, noting similar elements of deliberate deceit and a reckless disregard for the licensing laws, really underscoring how seriously they view this type of conduct.
Okay, so after these lengthy hearings, months of deliberation presumably, what was the final verdict from the tribunal on liability?
The tribunal handed down its comprehensive judgment, 98 pages long, on liability on August 9, 2024, and the outcome was clear-cut. Patrick Mack was found guilty of unsatisfactory professional conduct and, more seriously, guilty of professional misconduct.
Professional misconduct, that's the really serious one, isn't it?
It is. It signifies a substantial failure to meet the standards expected or suggests a fundamental lack of fitness to practice law. It's a very grave finding for any lawyer.
Let's break down the specific findings. First, on the unlicensed practice charge, ground 1.
Okay. The tribunal found that ground 1, engaging in practice or holding himself out as entitled to practice while unlicensed, amounted to professional misconduct. Their reasoning went back to the evidence. They found it involved deliberate deceit, telling people he could take the case when he knew he was barred, and a reckless disregard for the law. They explicitly referenced the Dwyer case comparison here.
Did they pinpoint the moment he crossed the line?
They stated they were comfortably satisfied that Mack had, at times when he could not permissibly do so, agreed to provide legal advice to Mrs. S and his son. And they said this conduct was the very definition of engaging in legal practice while unlicensed, a clear breach of LPUL sections 10, 1, and 11.
Okay. And what about accepting the $3,000 fee? Ground two.
That ground was also proven. The tribunal found it was, at the very least, unsatisfactory professional conduct. But given the deception involved in obtaining it while unlicensed, they suggested it likely also rose to the level of professional misconduct. This breached another key rule, Uniform General Rule 15, which basically says you can't charge fees if you're not legally entitled to practice.
And the elaborate scheme, the Christmas Eve visit, how did they formally find us for him?
They dedicated a significant part of the judgment to analyzing that incident. They confirmed their view that it was orchestrated purely for Mack's own benefit, a calculated, elaborate scheme to dodge the consequences of Mrs. Sina's complaint. They reiterated he had no lawful basis to hang on to her money once she'd complained.
And the conduct itself.
He strongly condemned his attempt to make the refund conditional on her signing that self-serving declaration. They emphasized again the severe conflict of interest and the exploitation of a vulnerable layperson. And as we mentioned, this specific conduct, the scheme itself, was found to breach Barrister's rules, Rule 8C. It was conduct likely to diminish public confidence in the legal profession or bring it into disrepute.
So the attempted cover-up was formally judged as damaging the profession's standing. The sources describe the tribunal's language as blistering.
Yes, the judgment apparently used very strong terms. It emphasized that Mack's actions violated fundamental principles of honesty and independence that are expected of all barristers. They found his conduct showed a significant failure to meet those high standards, effectively trampling on the conduct rules that demand integrity.
Now, this finding of professional misconduct, that wasn't the absolute final step in the NCAT process, was it?
No, that's correct. The August 9, 2024 judgment determined liability. It established that he was guilty of professional misconduct and unsatisfactory professional conduct. The next stage is the penalty phase, or the disposition hearing.
What happens there?
That's where the tribunal decides the appropriate disciplinary order, the consequences. The sources note that proceedings were listed for this Stage 2 hearing on October 28, 2024. The potential outcomes could range from a formal reprimand to a suspension from practice for a period, or even the most severe penalty, removal from the role of lawyers, which means being struck off.
And all of this, particularly the more, colorful details, attracted media attention.
It certainly did. The sources specifically mentioned that the case, especially elements like the cash payment from the client's mother, the Christmas Eve PI visit, the statutory declaration, it was considered highly newsworthy within the legal community. Legal news outlets reported on the tribunal's findings, with headlines focusing on that elaborate scheme.
Which just underscores that this kind of serious misconduct doesn't happen in a vacuum. It gets exposed.
Absolutely. It reinforces that transparency and accountability are operating, even if the process takes time.
It's a really complex, troubling story. So many missteps, so much deceit alleged and found. But boiling it down, what are the absolute critical lessons that anyone in the legal profession, especially maybe those just starting out or aspiring barristers, should take away from this deep dive?
Well, this case, tragically, provides several really fundamental lessons, ones that just cannot be stressed enough. The first, the most basic, is the absolute non-negotiable primacy of holding a valid practicing certificate.
Rule number one.
Rule number one. LPUL sections 10 and 11 are not suggestions. They are strict prohibitions. You simply cannot engage in legal practice or even hold yourself out as being able to practice without a current, valid PC, full stop. There are no loopholes, no exceptions for calling it consultancy if the work you're actually doing is legal advice or preparing for litigation. Mack's hope or belief that he might get his PC back, totally irrelevant. You can't practice based on anticipation.
No license, no legal work. Got it. What's next?
Second, and this screams out from both the Mack case and the Dwyer case before it, the absolute necessity for candor and honesty with your regulator. It's non-negotiable.
Being upfront.
Completely upfront. Mack's multiple failures to notify the Bar Council promptly about his charges and convictions, and then his later defense, which the tribunal found was a reconstruction, it echoes the deliberate lies and misleading conduct that got Dwyer struck off. Trying to hide things, being evasive, being less than completely honest with the Bar Council or NCAT, it's a massive aggravating factor. It's fundamentally incompatible with the fitness required to practice law.
You just can't build a career on deceit towards the very body that licenses you. Makes sense.
And third, You cannot escape regulatory oversight. There's a powerful phrase used in the sources that these cases perfectly illustrate. You cannot pick and choose your regulators. Meaning, attempts to sidestep scrutiny don't work. Dwyer tried conducting work partly in Queensland, maybe hoping to muddy the waters with NSW regulators. Mack seemed to think he could operate in this supposed consultancy gray area. Neither strategy offered any protection. Superior courts have inherent jurisdiction over lawyers. Regulators like the Bar Council and NCAT have broad powers to investigate and discipline conduct, regardless of where it happened or even if some time has passed. There is, as the sources vividly put it, no refuge in delay or geography.
Wow. So the standards apply and they will eventually catch up with you.
That's the clear message. Fourth, a crucial lesson comes directly from Mack's dealings with Mrs. Sina after she complained the whole statutory declaration scheme. It's a stark warning about conflicts of interest.
Especially with vulnerable clients.
Exactly, especially when dealing with a former client about a complaint they've made against you. And particularly when that client is a layperson, maybe less legally savvy, potentially vulnerable. Trying to resolve a complaint directly like that, especially by dangling a refund conditional on them signing a document that benefits you, it's a massive conflict, it's exploitative, and as NCAT found here, it's conduct that diminishes public confidence in the entire profession.
It really underlines that your ethical duties extend way beyond just the courtroom work. It includes how you handle criticism or complaints about yourself.
Absolutely. Fifth, the case helps clarify what actually constitutes legal practice. Remember Mack's consultancy argument?
Yeah, that it wasn't legal work.
Right. But as the Dwyer case established, and as applied here, engaging in legal practice means doing something usually done by a lawyer in a way that implies you are a lawyer. That includes giving professional legal advice or conducting litigation strategy. Mack's work, analyzing evidence, assessing warrants, planning strategy for a criminal case, even if he labeled it consultancy, it involved applying legal principles to a client's specific legal problem. That is legal practice. The label doesn't change the substance.
You can't just call legal advice something else to get around the rules.
Yeah.
Seems obvious, but clearly important.
And finally, related to that, Mack's case really drives home that integrity is demanded in all aspects of your professional life. It's not just about courtroom advocacy, conduct outside the court, like how you handle client money, accepting cash outside proper trust procedures, or orchestrating a scheme involving a private investigator. That conduct is absolutely subject to scrutiny under the conduct rules, like Rule 8C, if it has the potential to damage public trust in the profession.
Like the Christmas Eve scheme did.
Exactly. It all comes back to this. Being a barrister isn't just a job. It's a position of significant public trust, carrying heavy ethical obligations. Breaching fundamental rules, especially around licensing and basic honesty, has incredibly severe, potentially career-ending consequences.
This deep dive into Patrick Mack's case, it's been a difficult story to unpack, but it holds some incredibly valuable, if hard-learned, lessons.
It really is a stark reminder, isn't it? A career built over many years can unravel with frightening speed through, it seems. A combination of personal pressures, terrible judgment calls about regulatory duties, fundamental dishonesty, and then attempts to cover up the initial wrongdoing. Mack's story, much like Dwyer's before him, just hammers home the critical importance of upholding the absolute core principles of the legal profession.
And for you, our listener, particularly if you're maybe thinking about law school, or you're a junior lawyer, or aspiring to the bar, this case isn't just some abstract cautionary tale about one person's failings. It's a vital, real-world lesson in professional ethics, in compliance, and in the absolute necessity of candor honesty with everyone you deal with professionally. Your clients, your colleagues, and maybe most importantly, your regulator. These rules, these standards, they exist for very good reasons. They protect the public, and they maintain the integrity of the profession that you are or want to be a part of.
Yeah, it clearly shows the standards are incredibly high, and the consequences for failing to meet them are just as significant.
Which kind of leaves us with a final thought, something to maybe ponder as we wrap up this deep dive. In a profession where trust really is the ultimate currency, how constantly vigilant must you be? Not just about knowing the rules, the letter of the law, but about the strength and reliability of your own ethical compass. Because especially when those personal or professional pressures inevitably mount, as we've seen so clearly here, the consequences of letting that compass waver even slightly can be truly absolute and utterly devastating.